Ho, ho, ho. Welcome back, my ambitious legal scholars. I'm Professor Albert J. Legalis, Dean and founder of Legalis Law School, and I have wonderful news for you. You see, here at Legalis Law School, it's always Christmas. Every day of the year, we're in the business of giving gifts. The gift of legal knowledge, the gift of professional competence, and the gift of confidence in the courtroom. And today's gift is something that could literally save your freedom, a complete guide to mastering New York criminal procedure from arrest through appeal. Whether you're a defense attorney protecting your client's constitutional rights, a prosecutor seeking justice while respecting due process, or someone facing criminal charges who needs to understand the system, this course is your roadmap through New York's complex criminal justice system. Now, some people say, Professor Legalis, why do you give away so much valuable legal education for free? And I tell them, because knowledge is meant to be shared, because justice requires educated advocates, because every person who understands their constitutional rights makes our democracy stronger, and because in criminal law, the stakes aren't just money or property, they're freedom itself. The Constitution doesn't guarantee you'll win your case, but it does guarantee you'll get a fair fight. Today's course ensures you know how to demand that fairness and recognize when you're not getting it. So consider this course your early Christmas present, your late Christmas present, or your everyday Christmas present, because at Legalis Law School, the spirit of giving never ends and constitutional rights never take a holiday. Now let's unwrap this gift together and dive into New York criminal procedure. Justice is waiting, and we're going to make sure you're ready for it.
The first 48 hours after arrest often determine the entire outcome of a criminal case. I'm retired New York Supreme Court Justice Michael Torres, and after 20 years presiding over criminal cases from arraignments to sentencing, I can tell you that what happens in those crucial first hours sets the tone for everything that follows. Let me show you how to navigate these critical initial proceedings and protect your rights from the very beginning. First, understand New York's criminal court structure. Local criminal courts handle misdemeanors and the initial stages of felony cases. This includes city courts, town and village courts, and district courts. These courts conduct arraignments, preliminary hearings, and trials for misdemeanors. Supreme Court handles felony trials and sentencing. But here's what confuses people. Even felonies start in local criminal court for arraignment. The case only moves to Supreme Court after indictment by a grand jury or waiver of that right. Now let's talk about arraignment, your first and most critical court appearance. Under CPL 180.10, you must be arraigned without unnecessary delay and for warrantless arrests. That means within 24 hours of arrest, not counting Sundays and holidays. At arraignment, several crucial things happen simultaneously. The charges are formally read, you enter a plea, bail is set, or you're released on your own recognizance, and your right to counsel is addressed. Miss any of these elements, and the arraignment is defective. Here's what I've seen from the bench. Most people focus only on bail, but the plea is equally important. You typically plead not guilty at arraignment, preserving all your rights and defenses. Don't even think about pleading guilty without counsel unless the charge is a simple violation. For bail decisions, New York's Bail Reform Act has fundamentally changed what judges can consider. We can no longer set bail simply to protect public safety. Bail is only allowed for specific enumerated offenses, and even then, it must be the least restrictive means to ensure your return to court. I consider your ties to the community, your history of court appearances, the seriousness of the charges, and your ability to pay. What I cannot consider anymore is whether you might commit new crimes. This is a huge change from pre-2020 practice. The right to counsel attaches immediately at arraignment. If you cannot afford counsel, the court will assign an attorney through the local assigned counsel plan or public defender's office. This isn't charity. It's your constitutional right under the Sixth Amendment. But here's what many people don't understand. The quality of assigned counsel varies dramatically by county. Some public defender offices are excellent, others are overwhelmed. If you can afford private counsel, especially for serious felonies, it's often worth the investment. Financial eligibility for assigned counsel is determined by court guidelines, but there's often flexibility. Don't assume you don't qualify. Let the court make that determination based on your actual financial circumstances. Now about timing and deadlines. The prosecution has strict timelines under CPL 180.80 for filing informations and conducting preliminary hearings. For felonies, they must file a felony complaint and move toward grand jury presentation or preliminary hearing within specific timeframes. From my experience on the bench, cases often get dismissed because prosecutors miss these deadlines. Pay attention to them and make sure your attorney files appropriate motions, when the people fail to meet their obligations. Here's practical advice for anyone facing criminal charges. Treat your arraignment seriously even if it seems routine. Dress appropriately, arrive early, and speak only when asked direct questions by the court. Your behavior at arraignment influences my impression for the entire case. If you're representing yourself, which I strongly discourage for anything beyond simple violations, request an adjournment to obtain counsel. Almost every judge will grant this request because we'd rather deal with represented defendants. For family members attending arraignment, understand that this is often your only chance to provide character information for bail purposes. Bring documentation of community ties, employment, and family responsibilities. These factors matter in bail decisions. The conditions of release set at arraignment are crucial. Violate them and you'll likely be remanded without bail. Common conditions include staying away from victims, surrendering passports, and checking in with pretrial services. Take these seriously. Remember, arraignment is just the beginning. What happens there affects plea negotiations, trial strategy, and sentencing. Get it right from the start, and you're positioned to fight effectively throughout your case. Attorney Washington will now explain how to protect your constitutional rights during the arrest and investigation process.
Your constitutional rights don't disappear when handcuffs go on, but you need to know how to protect them. I'm Rachel Washington, criminal defense attorney with 15 years fighting for constitutional rights in New York courtrooms, and I'm going to show you how to preserve your 4th, 5th, and 6th Amendment protections from the moment of arrest. The 4th Amendment protects against unreasonable searches and seizures, but what's reasonable has been litigated for decades. Let me give you the practical reality of how these rights work on the street and in the courtroom. Police need probable cause to arrest you without a warrant. That means facts and circumstances that would lead a reasonable person to believe you committed a crime. It's more than suspicion, but less than proof beyond a reasonable doubt. A smell of marijuana, suspicious behavior in a high crime area, or matching a suspect description can all contribute to probable cause. But here's the key. Even with probable cause to arrest, police cannot search wherever they want. The search incident to arrest doctrine allows them to search your person and the area within your immediate control for weapons and evidence. That means your pockets, a purse you're carrying, or the area you could reach to grab a weapon. Your car is different. Police can search the passenger compartment incident to arrest only if you might access it or if evidence of the crime of arrest might be found there. For most arrests, they'll need a warrant or your consent to search the trunk or locked containers. Here's where people make critical mistakes. They consent to searches they don't have to allow. You have the absolute right to refuse consent to search your home, car, or belongings. Police might pressure you, saying things like, if you have nothing to hide, or it'll go easier if you cooperate, don't fall for it. The magic words are, I do not consent to any search. Say it clearly, say it repeatedly, and don't physically resist if they search anyway. You preserve your rights for court while avoiding additional charges for obstruction. Stop and frisk under Terry v. Ohio allows police to briefly detain you based on reasonable suspicion, a lower standard than probable cause. They can pat down your outer clothing for weapons if they reasonably believe you're armed and dangerous. But this isn't a general search. They're looking for weapons, not evidence. If police find contraband during a valid Terry frisk, it can be seized. But if the frisk exceeds its scope, reaching into pockets when they feel something that's clearly not a weapon, that evidence might be suppressed. Now for Miranda rights, which protect your 5th Amendment right against self-incrimination. Contrary to TV shows, police don't have to read Miranda immediately upon arrest. They only need Miranda warnings before custodial interrogation. Custody means you're not free to leave. Interrogation means questioning designed to elicit incriminating responses. If you're in custody and being interrogated without Miranda warnings, your statements can't be used against you at trial. But here's the trap. Anything you say before you're in custody or after you're in custody but before interrogation can be used against you. The conversation in the patrol car, comments at the scene, volunteered statements, all admissible if not the product of custodial interrogation. Your Miranda rights include the right to remain silent and the right to counsel. If you invoke either right clearly and unambiguously, questioning must stop, but courts require clear invocation. Saying maybe I should talk to a lawyer isn't enough. Say I want a lawyer or I'm invoking my right to remain silent. Once you invoke, don't change your mind without counsel present. Police can't reinitiate questioning after you invoke your right to counsel, but they can continue if you bring up the conversation again. Suppression motions under CPL 710.20 are how we challenge illegally obtained evidence. These motions must be filed within 45 days of arraignment, or you waive the right to challenge the evidence. The people have the burden to prove the legality of police conduct. Huntley hearings determine the admissibility of statements. MAP hearings challenge physical evidence from searches. Dunaway hearings attack the legality of the initial detention. Wade hearings challenge identification procedures. Know which hearing applies to your evidence issues. Here's my practice tip. Document everything immediately. Police reports often differ from reality. Get witness information, take photos of injuries, and write down exactly what happened while it's fresh in your memory. This evidence is crucial for suppression motions. The exclusionary rule keeps illegally obtained evidence out of trial, but it has exceptions. The inevitable discovery doctrine allows evidence that would have been found anyway. The independent source doctrine permits evidence obtained through legal means separate from the illegal conduct. Good faith exceptions apply when police rely on defective warrants they reasonably believed were valid. But there's no good faith exception for warrantless searches. Those must meet an established exception to the warrant requirement. For digital evidence, police generally need warrants to search cell phones, even incident to arrest. The Supreme Court recognized in Riley v. California that cell phones contain vast amounts of personal information deserving heightened protection, but location data, call records, and other information held by third parties get less protection under the third-party doctrine. Police can often obtain this information with subpoenas rather than warrants. My final advice? Exercise your rights respectfully but firmly. Don't argue with police on the street. Preserve your arguments for court. Stay calm, comply with lawful orders, and remember that anything you say or do can be used against you later. The goal isn't to obstruct police investigations, but to ensure they follow constitutional procedures. When they don't, we have remedies in court to protect your rights and exclude illegally obtained evidence. Professor Mitchell will now explain how to challenge wrongful convictions and pursue appeals when the system fails.
A criminal conviction is not the end of the road. It's often the beginning of the appellate process. I'm Professor James Mitchell, criminal appellate specialist and law professor, and I'm going to show you how to challenge wrongful convictions and pursue every available remedy when the system fails. Criminal appeals in New York follow different rules than civil appeals, with shorter deadlines and more limited grounds. But understanding these procedures can mean the difference between serving an unjust sentence and winning your freedom. You have 30 days from sentencing to file a notice of appeal for most criminal convictions. This deadline is jurisdictional. Miss it, and your appeal rights are gone. Unlike civil cases, there's generally no extension available, so calendar this deadline immediately after sentencing. But here's what many don't understand. Your right to appeal depends on how you were convicted. If you went to trial and were convicted, you have an automatic right to appeal to the appellate division. If you pleaded guilty, your appeal rights are severely limited unless you preserve specific issues. Conditional pleas under CPL 220.30 let you preserve appellate rights while pleading guilty. You must get court approval and specifically identify the issues you want to appeal. Common preserved issues include suppression motion denials, jurisdictional challenges, and constitutional violations. For direct appeals, you're limited to issues that appear in the record or were properly preserved at trial. This means your trial attorney must have objected contemporaneously to preserve most issues. Failure to object generally waives appellate review except for rare fundamental errors. Ineffective assistance of counsel claims require showing both deficient performance and prejudice. The standard is high. You must prove counsel's performance fell below objective standards of reasonableness and that competent representation would have changed the outcome. Most ineffective assistance claims fail because courts give great deference to strategic decisions. Failing to call witnesses, not pursuing certain defenses, or plea negotiation strategies are usually considered tactical choices, unless clearly unreasonable. But some errors are so egregious they constitute per se ineffectiveness. Complete failure to investigate, sleeping during trial, or operating under conflicts of interest. These don't require showing prejudice because the right to counsel was constructively denied. When direct appeals fail or weren't available, CPL 440 post-conviction motions provide another avenue for relief. These motions can raise issues not in the trial record, including newly discovered evidence, constitutional violations, and jurisdictional defects. CPL 440.10 covers motions to vacate judgments. Common grounds include newly discovered evidence that would probably change the verdict, constitutional violations that weren't previously raised, and jurisdictional defects that void the conviction. The newly discovered evidence standard is extremely difficult to meet. The evidence must be material to guilt or innocence, likely to change the verdict if presented at trial, not cumulative to evidence already presented, and not discoverable through due diligence before trial. DNA testing has revolutionized post-conviction relief, CPL 440.30 allows DNA testing. When identity was an issue at trial, testing wasn't available during the original proceedings, and results would establish a reasonable probability of innocence. Actual innocence claims under CPL 440.10 require new evidence that is of such character and weight that it would probably change the result if offered at a new trial. This is an incredibly high standard, but it's been met in cases with DNA exonerations and recantations by key witnesses. Federal habeas corpus provides another layer of review after state remedies are exhausted. Under 28 U.S.C. 2254, federal courts can review state convictions for constitutional violations, but only after you've pursued all available state remedies. The Anti-Terrorism and Effective Death Penalty Act severely restricts federal habeas relief. You generally have 1 year from the conclusion of direct review to file, and federal courts can only grant relief if state courts unreasonably applied clearly established federal law. Procedural default rules can bar federal review if you failed to raise issues properly in state court. There are narrow exceptions for cause and prejudice or actual innocence, but these are difficult to establish. Here's my strategic advice for appellate practice. Start thinking about appeals during trial. Preserve objections to every adverse ruling, create a complete record of constitutional violations, and ensure all motions are properly briefed and argued. For post-conviction relief, timing is critical. Many CPL 440 motions must be filed within specific time limits, and delay can be fatal to your claims. Gather new evidence quickly and file promptly once you have grounds for relief. Don't pursue frivolous appeals or motions. Courts remember lawyers who file meritless claims, and it hurts your credibility for legitimate issues. Focus on your strongest arguments and present them persuasively. Remember that appellate and post-conviction practice requires specialized expertise. Criminal trial skills don't automatically translate to appellate advocacy. Consider hiring appellate specialists for serious felony convictions with viable issues. The statistics are sobering. Most criminal appeals and post-conviction motions fail, but when they succeed, they can restore freedom to the wrongfully convicted and correct fundamental injustices in our system. Mediator Kim will now show you how to navigate plea negotiations and alternative resolution programs that might avoid the need for appeals altogether.
95% of criminal cases end in plea bargains. Here's how to negotiate effectively. I'm David Kim, former prosecutor turned defense attorney and now mediator, and I've negotiated thousands of plea agreements from both sides of the table. Let me show you how to achieve the best possible outcome for your case. The first thing to understand is that plea bargaining is not a sign of weakness. It's strategic case resolution. Even with strong defenses, the risks of trial often make negotiated pleas the smartest choice. The key is negotiating from a position of knowledge and strength. There are 3 types of pleas in New York, and each serves different strategic purposes. A guilty plea is exactly what it sounds like: admission of guilt to the charged offense or a reduced charge. This waives your right to trial and most appellate issues. An offered plea under North Carolina v. Alford lets you maintain innocence while acknowledging that the prosecution has enough evidence to convict. This preserves some dignity while accepting the practical reality of likely conviction at trial. Conditional pleas under CPL 220.30 are the most strategically valuable. You plead guilty but preserve your right to appeal specific pretrial rulings like suppression motion denials. If you win the appeal, the plea is vacated. If you lose, the plea stands. Timing in plea negotiations is everything. Early plea discussions happen before formal charges, often during the investigation phase. These can result in declinations to prosecute, reduced charges, or cooperation agreements. Post-arraignment negotiations typically focus on charge reduction and sentencing recommendations. The prosecution has more leverage after formal charges, but you have better information about their evidence and legal theories. Pretrial negotiations intensify as trial approaches. Both sides face the uncertainty and expense of trial, creating pressure for resolution. This is often when the best plea offers are made. Here's what I learned as a prosecutor. We evaluate plea offers based on the strength of our evidence, the seriousness of the offense, the defendant's criminal history, and victim input. Understanding these factors helps you craft persuasive plea proposals. From the defense side, your leverage comes from legitimate weaknesses in the prosecution's case, strong mitigation evidence, and the costs and risks of trial. Don't bluff about defenses you can't prove, but don't undervalue real problems in their case. Diversion programs offer alternatives to traditional prosecution for appropriate cases. Drug courts address substance abuse issues through treatment rather than incarceration. Mental health courts provide specialized services for defendants with psychiatric conditions. Veterans courts recognize the unique challenges facing former service members and provide treatment for PTSD, substance abuse, and other service-related issues. These specialized courts often result in charge dismissals after successful program completion. Domestic violence courts focus on victim safety while providing batterer intervention programs. Success requires genuine acceptance of responsibility and completion of extensive counseling and education programs. Adjournment in contemplation of dismissal under CPL 170.55 for misdemeanors and CPL 215.10 for felonies allows charges to be dismissed after a period of good behavior. This isn't technically a conviction, preserving your record for most purposes. Conditional discharge under penal law section 65.05 results in conviction but no jail time if you comply with court-ordered conditions. These might include community service, restitution, counseling, or staying away from victims. Here's my negotiation strategy from years of practice. Start with thorough case analysis. Know the strengths and weaknesses of both sides. Research the prosecutor's track record and the judge's sentencing patterns. This information guides your negotiation approach. Prepare compelling mitigation packages that tell your client's story. Employment records, educational achievements, community ties, character letters, and evidence of rehabilitation all influence prosecutorial discretion. Address victim concerns proactively. Genuine remorse, meaningful restitution, and credible efforts to prevent future harm can transform adversarial negotiations into collaborative problem solving. Don't negotiate in a vacuum. Understand the realistic trial outcomes and sentencing exposure. Your plea offer must be better than the likely result at trial, accounting for the risks and costs of litigation. Multiple offer strategies work well in complex cases. Present several plea options at different charge levels with corresponding sentence recommendations. This gives prosecutors flexibility while ensuring you get proportional reductions. Document all plea discussions carefully. Misunderstandings about plea terms lead to withdrawal motions and appeals. Ensure all conditions are clearly stated and understood by everyone involved. Remember that prosecutors have supervisory approval requirements for significant plea reductions. Building relationships with line prosecutors helps, but understand they may need approval for substantial departures from standard policies. From my mediation experience, I can tell you that most criminal cases have resolution possibilities if both sides approach negotiations creatively and realistically. The goal isn't to win the negotiation, but to achieve the best possible outcome given the circumstances. My final advice: enter plea negotiations with clear goals and realistic expectations. Know your bottom line and be prepared to go to trial if reasonable offers aren't forthcoming. The threat of trial must be credible to generate meaningful plea discussions. Professor Chen will now show you how to use New York's criminal discovery rules to build the strongest possible case for trial or negotiation.
Criminal discovery in New York has been revolutionized. Here's what you need to know. I'm Professor Sarah Chen, former prosecutor and criminal procedure specialist, and I'm going to show you how to use New York's transformed discovery rules to build the strongest possible case, whether you're defending or prosecuting. The 2019 discovery reforms under CPL Article 240 fundamentally changed criminal practice in New York. These changes shifted us from a system where prosecutors controlled information flow to one requiring broad, early disclosure. Understanding these new rules is essential for effective criminal practice. Under CPL 240.20, prosecutors must now provide automatic disclosure within 15 days of arraignment for most cases, or 35 days for superior court informations. This isn't discretionary. It's mandatory disclosure that happens without any defense request. The prosecution must disclose all items and information in their possession, custody, or control. This includes police reports, witness statements, expert reports, photographs, audio and video recordings, and any evidence favorable to the defense. Here's the game changer. Prosecutors must disclose the names and contact information of all persons with knowledge of relevant facts. This means witness lists that were previously closely guarded secrets are now provided automatically. But there are important exceptions to disclosure. The prosecution can seek protective orders to delay disclosure of witness information if there's a reasonable likelihood of witness intimidation or harm. They can also withhold ongoing investigation materials in certain circumstances. Brady material, evidence favorable to the defense, now has specific disclosure requirements. Prosecutors must disclose exculpatory evidence, impeachment material, and information that tends to negate guilt or reduce punishment. The old practice of late Brady disclosures is no longer acceptable. The prosecution must also disclose all evidence of misconduct by law enforcement personnel involved in the case. This includes disciplinary records, credibility issues, and any evidence that officers have lied in previous cases. This is often called Giglio material after the Supreme Court case. Electronic evidence requires special attention under the new rules. Body camera footage, dash cam videos, cell phone recordings, and digital communications must all be disclosed. The prosecution must provide this evidence in usable formats, not just still photographs or transcripts. Chain of custody documentation is now more important than ever. Prosecutors must disclose how evidence was collected, stored, and handled. Any gaps in the chain of custody become potential suppression issues that must be disclosed early. Reciprocal discovery under CPL 240.30 requires defense disclosure in response to prosecution compliance. If you plan to rely on alibi, mental disease or defect, or justification defenses, you must provide notice and supporting information within 30 days of prosecution disclosure. Defense witness lists are generally not required, but if you plan to call expert witnesses, you must disclose their qualifications and the substance of their expected testimony. This prevents surprise expert testimony that could unfairly prejudice the prosecution. Here's what prosecutors struggle with under the new rules. The volume of material requiring disclosure is enormous. Every police report, every witness interview, every piece of digital evidence must be reviewed and produced. This has strained prosecutor offices statewide. For defense attorneys, these changes create both opportunities and obligations. You now get far more information early in the case, allowing better case evaluation and plea negotiations. But you also have reciprocal obligations that must be met within strict deadlines. Discovery violations under CPL 240.70 carry serious sanctions. Courts can exclude evidence, grant adjournments, give adverse jury instructions, or in extreme cases, dismiss charges. The key is showing that violations were willful or in bad faith. But here's the practical reality. Most discovery violations result in adjournments rather than dismissals. Courts are reluctant to dismiss cases for discovery violations unless the prosecution's conduct was particularly egregious or prejudicial. My practice tip for prosecutors: develop systematic disclosure procedures to ensure compliance. Create checklists, use technology for evidence management, and disclose early rather than risk sanctions. The new rules require fundamental changes in how prosecutor offices operate. For defense attorneys, review discovery materials immediately and thoroughly. Look for Brady material that might not be properly identified, chain of custody issues, and opportunities for suppression motions. Early discovery review often reveals defenses not apparent from initial charging documents. Pay special attention to digital evidence authentication. Just because the prosecution has a video or audio recording doesn't mean it's admissible. Chain of custody, authentication, and best evidence rule issues can all affect admissibility. Electronic evidence also raises privacy and Fourth Amendment issues. Cell phone data, GPS location information, and social media evidence often require warrants. Challenge evidence obtained without proper legal process. Expert witness disclosure works both ways. If the prosecution plans to use forensic experts, ballistics testimony, or medical evidence, they must disclose the expert's qualifications and opinions. This allows you to prepare cross-examination and retain opposing experts. Witness statement inconsistencies become more important under the new rules. With automatic disclosure of all witness statements, you can identify changes in stories, inconsistencies between statements, and evolution in witness accounts over time. Here's my strategic advice. Use early discovery to evaluate cases for plea negotiations. More information earlier allows better assessment of trial risks and appropriate plea discussions. Don't wait until trial preparation to analyze discovery materials. Document preservation becomes crucial under the new rules. Both sides must preserve all potentially relevant evidence, including electronic communications, social media posts, and surveillance footage. Failure to preserve evidence can result in sanctions. The new discovery rules have made criminal practice more transparent but also more complex. Success requires adapting to new procedures, managing larger volumes of information, and understanding the strategic implications of early, broad disclosure. Attorney Rodriguez will now show you how these discovery materials translate into effective trial advocacy and jury selection strategies.
Criminal trials are where constitutional rights meet courtroom reality. I'm Lisa Rodriguez, criminal trial specialist with 15 years defending constitutional rights in New York courtrooms, and I'm going to show you how to protect and exercise your fundamental trial rights when your freedom is on the line. The Sixth Amendment guarantees your right to a speedy trial, but what constitutes speedy is defined by New York's CPL 30.30, not your sense of urgency. Under this statute, the prosecution must be ready for trial within specific time limits: 90 days for felonies, 60 days for misdemeanors punishable by more than 3 months, and 30 days for other misdemeanors. But here's the critical detail. Not all time counts toward these limits. Periods of delay caused by the defense, court congestion beyond prosecution control, and certain procedural delays are excludable. The prosecution gets credit for time when they're ready, but you're not. Common excludable delays include defense motions, psychiatric examinations, DNA testing, and periods when defendants are unavailable due to other proceedings. Understanding what time counts is crucial because CPL 30.30 violations result in case dismissal, not just faster trial dates. From my trial practice, I can tell you that successful CPL 30.30 motions require meticulous record keeping. Document every adjournment, who requested it, and the stated reasons. Prosecutors often claim excludable time that doesn't actually qualify for exclusion. Your right to trial by jury applies to all crimes punishable by more than 6 months imprisonment. In New York, that means virtually all misdemeanors and all felonies. You can waive jury trial and proceed with a bench trial before a judge, but this decision requires careful strategic consideration. Jury selection in criminal cases differs significantly from civil practice. The prosecution and defense each get unlimited challenges for cause when jurors demonstrate actual bias or inability to be fair. Peremptory challenges are limited, typically 20 for each side in murder cases, 10 for other felonies, and 3 for misdemeanors. During voir dire, we're looking for jurors who can fairly evaluate the evidence and apply the presumption of innocence. Watch for jurors who seem prosecution-friendly due to law enforcement connections, crime victimization, or strong law and order attitudes that might prevent fair consideration of defense evidence. The burden of proof in criminal cases is proof beyond a reasonable doubt, the highest standard in our legal system. This means the prosecution must prove every element of every charge to a level where reasonable people would not hesitate to rely on it in making important decisions. Here's what juries often misunderstand. Reasonable doubt doesn't mean all possible doubt or beyond any doubt. It's the doubt that would cause reasonable people to pause before acting. As defense attorneys, we must help juries understand this standard without appearing to diminish its significance. The presumption of innocence is more than a legal technicality. It's the foundation of our criminal justice system. Defendants don't have to prove their innocence or present any evidence at all. The prosecution bears the entire burden of proving guilt beyond a reasonable doubt. Your right to remain silent at trial is absolute. You cannot be compelled to testify, and the prosecution cannot comment on your decision not to take the stand. The judge will instruct the jury that they cannot draw any negative inferences from your silence. But the decision whether to testify is often the most difficult strategic choice in criminal defense. Testimony can humanize you and provide explanations for seemingly damning evidence, but it also opens you to cross-examination and potential impeachment with prior convictions. If you do testify, the prosecution can impeach you with prior felony convictions from the past 10 years under Evidence Rule 609. The court balances the probative value against prejudicial effect, but prior convictions for crimes involving dishonesty are usually admissible. Your right to confront witnesses means more than just being present during their testimony. It includes the right to cross-examine prosecution witnesses, to challenge their credibility, and to explore their biases, motives, and memory problems. The Confrontation Clause also limits the use of hearsay evidence. Testimonial hearsay, statements made in formal proceedings or to law enforcement, generally cannot be admitted unless the witness is unavailable and you had a prior opportunity to cross-examine them. This creates particular issues with forensic evidence. Lab reports, ballistics analyses, and other scientific evidence often constitute testimonial hearsay, requiring live testimony from the analyst who conducted the tests, not just supervisory personnel. Jury instructions are crucial to protecting your rights at trial. The court must properly instruct on reasonable doubt, presumption of innocence, and the prosecution's burden of proof. Object to inadequate instructions and request specific instructions that protect your constitutional rights. During deliberations, jurors sometimes ask questions that reveal misunderstanding of their role or the legal standards. Monitor jury notes carefully and object to any responses that might undermine constitutional protections or suggest burden shifting to the defense. Verdicts in criminal cases must be unanimous in New York. If even one juror has reasonable doubt, the proper verdict is not guilty. Hung juries result in mistrials, giving the prosecution another opportunity to try the case, but also providing additional preparation time for the defense. My final trial advice: never forget that you're fighting for someone's freedom, not just winning a case. Every constitutional protection exists because experience has taught us that liberty requires vigilant defense against government overreach. Prepare thoroughly, advocate zealously, and remember that reasonable doubt isn't just a legal standard, it's the barrier between freedom and wrongful conviction in our imperfect system. Professor Legalis will now explain how sentencing works when trials don't end in acquittal, and how understanding sentencing options can influence trial strategy and plea negotiations.
Most people facing criminal charges will work with a public defender, and understanding this relationship can make the difference between effective representation and falling through the cracks. I'm attorney Michael Santos, senior public defender with 12 years fighting for indigent clients in New York courts, and I'm going to show you how to be an effective client and protect your rights within the public defense system. First, let's be honest about the reality. Public defenders are real lawyers with the same legal training as private attorneys, but we carry enormous caseloads that limit the time we can spend on each case. I might have 150 active felony cases at any given time. This doesn't mean you get inferior representation. It means you need to be a smart, engaged client. Your right to counsel under the Sixth Amendment guarantees you an attorney, but it doesn't guarantee you unlimited attorney time or resources. Understanding this distinction helps set realistic expectations while ensuring you get the effective assistance you're entitled to. Here's how to maximize your public defender relationship. Be organized, be prepared, and be realistic about what we can accomplish together. Come to meetings with written questions, important dates, and any documents related to your case. The more organized you are, the more efficiently we can use our limited time together. Communication is critical, but must be strategic. Don't call your public defender daily with minor questions. Save important issues for scheduled meetings or genuine emergencies. But do communicate immediately about new arrests, violations of conditions, or changes in your circumstances that might affect your case. If you're not satisfied with your public defender's representation, you have options, but they're limited. You can request substitute counsel, but you must show good cause, actual conflicts of interest, complete breakdown in communication, or incompetent representation. Personality conflicts or disagreements about strategy aren't enough. Here's what public defenders need from clients to be effective: honesty about your criminal history, complete information about the facts of your case, and realistic expectations about possible outcomes. Don't lie to us about prior convictions or what happened. We can't help you if we don't know the truth. Many public defender offices have investigative and social work resources that private attorneys can't afford. Take advantage of mitigation specialists, mental health evaluators, and substance abuse counselors when available. These services can significantly improve your case outcome. Time management is crucial in the public defender relationship. Show up on time for meetings and court appearances. Prepare questions in advance. Bring relevant documents organized and ready to discuss. Respect our time constraints while ensuring your case gets proper attention. Don't try to supplement your public defender with legal advice from jailhouse lawyers, internet research, or well-meaning friends and family. This often creates confusion and conflicts with professional legal strategy. Trust your attorney's training and experience. My final advice: remember that public defenders chose this work because we believe in constitutional rights and equal justice. We didn't become public defenders to get rich. We do this because everyone deserves effective representation regardless of their ability to pay. Work with us as partners in your defense. Understand our limitations, but also appreciate our commitment to your constitutional rights. Together, we can navigate the criminal justice system and achieve the best possible outcome for your case. Professor Legalis will now share some final thoughts about this journey through New York's criminal procedure.
Ho, ho, ho. Well, my ambitious legal scholars, you've just received quite a gift, haven't you? You've learned from some of the finest legal minds in New York criminal practice. Judge Torres's courtroom wisdom about initial proceedings, Attorney Washington's constitutional expertise, Professor Mitchell's appellate knowledge, Mediator Kim's plea negotiation strategies, Professor Chen's discovery mastery, Attorney Rodriguez's trial advocacy skills, and Attorney Santos's invaluable guidance on working effectively with public defenders. That's the equivalent of years of expensive criminal law education, wrapped up and delivered to you in under 30 minutes. From arraignment to appeal, from constitutional rights to public defense, You now have the tools to navigate New York's criminal justice system effectively. But remember, knowledge without action is just expensive entertainment. Take what you've learned today and put it to work. Whether you're protecting constitutional rights, negotiating pleas, or working with public defenders, you now have the foundation to succeed. You've been very good students this year, so you've earned a permanent spot on my nice list of educated legal professionals. And because it's always Christmas at Legalis Law School, we have more gifts waiting for you. Check out our complete course catalog for civil procedure, federal practice, and specialized areas of law. Subscribe to our channel so you never miss new courses, and share this gift of knowledge with other legal professionals who need it. Remember, every lawyer who succeeds makes the entire profession stronger, and every person who understands their constitutional rights makes our democracy safer. Until next time, this is Professor Albert J. Legalis reminding you that at Legalis Law School, the spirit of learning never ends, and justice never takes a holiday. Ho, 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 and happy lawyering.